Hello Michigan Realtors and welcome back to The Letter of the Law, a monthly video series designed to provide a primer on various legal issues impacting your industry. I'm Brian Westron and today's legal primer will be on the topic of escalation clauses. Now in many areas in Michigan, shrinking inventories have caused some buyers to resort to something called an escalation clause. These buyers have lost out on too many bidding wars for their dream home and do not intend to lose again. Now, a hypothetical is the easiest way to examine the ins and outs of escalation clauses. Now, assume buyer A makes an offer on 123 Elm Street for its list price, $150,000. Buyer A's offer goes on to provide that buyer A will increase his offer by $2,000 more than any competing offer made for 123 Elm Street. This is the escalation clause. Now, does the use of the escalation clause pose risks to buyers A? Most certainly it does. The question is whether those risks can be reduced or eliminated. The escalation clause on its face subjects buyer A to limitless financial exposure. If buyer A offers $150,000 on 123 Elm Street, a competing offer could be received for $300,000, making buyer A contractually liable to $302,000. Now this risk can be reduced by using the following. Buyer A will increase his offer by $2,000 more than any competing offer made for 123 Elm Street in an amount not to exceed $160,000. Now the revised escalation clause still could subject buyer A to fake competing offers. Suppose the seller's cousin submits an offer for $158,000. Buyer A could be on the hook for $160,000. Buyer A can attempt to reduce this risk by adding the words bona fide or good faith into the escalation clause as follows. Buyer A will increase his offer by $2,000 more than any bona fide or good faith competing offer made for 123 Elm Street in an amount not to exceed $160,000. While the terms good faith or bona fide may be ambiguous enough to result in a lawsuit, any attempt to further define those terms will only make the paragraph longer. Buyer A could further try to protect himself from fake offers by indicating he will only pay $2,000 more than any competing offer if it is supported by a bank pre-qualification or pre-approval letter indicating the second buyer is indeed qualified to purchase 123 Elm Street at the price offered by that buyer. It could provide as follows. Buyer A will increase his offer by $2,000 more than any bona fide or good faith competing offer made for 123 Elm Street in an amount not to exceed $160,000. Buyer A must be provided with a copy of the competing offer together with a bank pre-qualification or pre-approval letter demonstrating to buyer A's sole satisfaction that the second buyer is qualified to purchase 123 Elm Street at the price set forth in the competing offer. As most realtors are aware, many lenders freely offer various forms of pre-qualification or pre-approval letters. Thus, the effectiveness of this requirement as proof of ability to pay may be limited. Buyer A could also protect himself by inserting other contingencies in the contract to provide himself with an out in the event the contingencies in the escalation clause fail. For example, Buyer A could insert a contingency which permits him to elect to terminate the purchase agreement if the property does not appraise at the amount equal to the purchase price. Alternatively, Buyer A could include an extremely broad inspection clause. Further, if Buyer A's contract is contingent on financing, he may well be protected if the property will not appraise to support the higher purchase price. The problem, of course, is the insertion of any or all of these additional contingencies may make a buyer's offer less desirable to the seller. Buyer A must also determine how long he wishes to be at risk through the escalation clause. He can address this risk by putting an end date on the escalation clause. This would provide as follows. Buyer A will increase his offer by $2,000 more than any bona fide or good faith competing offer for 123 Elm Street in an amount not to exceed $160,000. Buyer A must be provided with a copy of the competing offer together with a bank pre-qualification or pre-approval letter demonstrating to Buyer A's sole satisfaction that the second buyer is qualified to purchase 123 Elm Street at the price set forth in the competing offer. This offer shall remain effective until 5 days after the date of this offer. Buyer A also needs to make sure that his contract with the escalation clause and the competing offer are compared as apples to apples. Assume that the competing offer is $158,000, but with $8,000 of seller's concessions and $2,000 for personal property. Would buyer A be bound to pay $160,000, or would the competing offer be treated as having an equivalent value of $148,000? There is no Michigan case law or statute on this issue. Now, in order to address this potential problem, buyer A will have to define how the amount of any competing offer will be determined. For example, it could provide as follows. Buyer A will increase his offer by $2,000 more than any bona fide or good faith competing offer made for 123 Elm Street in an amount not to exceed $160,000. Now, buyer A must be provided with a copy of the competing offer together with a bank pre-qualification or pre-approval letter demonstrating to buyer A's sole satisfaction that the second buyer is qualified to purchase 123 Elm Street at the price set forth in the competing offer. Now, this offer shall remain effective until 5 days after the date of this offer. Prior to increasing the purchase price pursuant to this paragraph, the total of all seller's concessions and any separate consideration for personal property provided for in the competing offer shall be deducted from the purchase price contained in said offer. In addition to the aforementioned possibility that your escalation clause could become increasingly lengthy and nuanced, the potential for conflict increases simultaneously if more than one competing offer has an escalation clause. What happens if buyer A submits his escalation clause without a cap and another buyer submits a substantially similar escalation clause, for example, $1,500 more than any competing offer? Obviously, the price cannot continue to increase into infinity. Can the seller accept both of the competing escalation clause offers, or would the unsuccessful buyer have standing to object? Do the two competing escalation clauses cancel each other out? As can be seen, it is not possible to eliminate all risks in the use of an escalation clause. In the event of ambiguities or disputes, a court may determine that an escalation clause is too vague to be enforceable. The risk of lengthy and expensive litigation must be taken into consideration when considering the use of an escalation clause. Now, as always, thank you for tuning in and watching this legal video primer. If you have questions or would like to suggest topics for future videos, please send suggestions to the email below. Again, thanks for watching and see you next time.